Good evening. This is Rahul Reddy live here from Houston, Texas. Every week on Tuesday at 5 p.m. Central Time, we do bring in business immigration news. Along with me is my business partner, Emily Neumann. Emily, now there is a pandemic going on. There's a COVID situation going on, and a lot of people are unemployed right now, and trillions of dollars are getting distributed to cover the damage that is happening with the COVID situation. What is the future? What do you see the future of the immigration right now? I mean, is there, there are a lot of rumors going on, Twitter's going on, the senator letters going on. People are paranoid with the COVID, and then you have on top of it, this immigration, people who are immigrants in this country are having extra thing. What is the future of them? What is the next 6 months, next 1 year, next 3 years, next 5 years, next 10 years? What do you think so is?
Well, that's a tough question to answer, but I think that you really have to look at different parts of immigration differently. If we're looking at high unemployment, we're going into recession potentially, generally that makes things more difficult for business immigration. Fewer companies are hiring, fewer companies are filing. The adjudication process gets more difficult. Labor certifications get audited more. So that part can be more difficult. At the same time, you've got these bills that are supporting healthcare workers and physicians and essential workers due to the COVID situation that might actually face a better time. And you have kind of these competing ideas, and then you've got the 4 Republican senators telling the president to block all non-immigrant immigration, which I don't think he actually has the power to do, and it's surprising that senators would offer to give him that power.
Give him the power, which they should be actually doing it by themselves if they wanted to.
Exactly. So we've been through recession before, where immigration was not as easy. Back in 2008, 2009, jobs were hard to come by. We might be headed that same direction because we're closing everything. People can't go to work. That's going to impact the economy. We've got high unemployment. That generally makes things more difficult for immigration.
But do you think so there will be a total ban on the entire business immigration like the way?
I don't think so. I don't think the president has the power to do that, and I don't think there's any way that Congress can get its act together to pass something like that would block everything.
It's only 4 members out of the 100 senators that have signed for this particular letter, though, but we don't even know in the details. So please, guys, don't get panicked on it. I've been through 2 recessions in this country as an immigration lawyer. It's going to have, of course, immigrants will have a tough time. There'll be more restrictions coming in. There will be a lot of people may have to move temporarily back to their home country if necessary. But in general, though, you don't panic right now. Try to work as hard as possible. There will not be an overall of immigration laws. There might be some slight twists here and there, as Emily was pointing at. There may be a healthcare bill that might be passed. We have also seen the essential healthcare workers bill introduced today. Essential immigration provisions have been introduced in the HEROES Act, which is proposed by the Nancy Pelosi and Democratic team. It is proposing to have some immigration, but mostly they are actually benefiting immigrants, nothing harming the immigrants though, except that one little provision which we saw in there was that the excess green cards, if there are any leftovers of the family, it should not be passed on to the business immigration, should be given to the family immigration. It's a 2,000 pages bill. We just have a little bit glimpse of it, but overall, you don't see any restriction on that bill at all. I mean,
no, it's very immigrant friendly. It extends deadlines, it extends status, it extends work authorization. It eliminates unlawful presence for people who couldn't leave during this time, provides for remote naturalization oath ceremonies so people can finally finish their naturalization process if they're in that. Provides more provisions specifically for physicians, more ability to change work locations without needing to file an amendment. This is specifically for physicians. So there are a lot of provisions targeted to physicians to make the immigration less of a burden so that they can actually handle the COVID-19 situation.
It has also provision where if your deadline falls, you can file within 60 days of the deadline, still be considered to have been filed properly. However, whatever Emily said about this bill, please don't consider that it's a done deal. It's just proposed by one side of the Congress. We expect a compromise bill that will be coming from both sides of it that might have a completely different things. At this point of time, there is nothing there in the Congress that is anti-immigration, is there?
Not in Congress. No.
Not in the Congress. Just to define what a Congress means, in United States we call Parliament as Congress. This is the highest authority to pass the law. And we don't, at the provisions that are moving in the Congress though, I mean, there might be all inactive bills which are not going to come into table, including the Senate 386 bill, which actually is very favorable to business immigration, but at this point of time, it's not active. The active bills that we see are actually more favoring business immigration. They're not trying to take away. So don't live in the fear, guys. Please be up. And the good part about it is that for the IT companies, though, they were not hit as hard as the rest of the industries are hit. Especially if you look into the hospitality industry, the entertainment industry, they've been very hard. IT is doing very good. So overall, I think so. You guys are much better situated if you're in the IT field. If you're in the healthcare field, you are definitely much better situated. The bills that are there in the Congress, the Parliament that we have here, seems to be in favor to you. They're not anti to you. So don't live in fear at this point of time. Emily, can you tell me about, is the USCIS working right now? The whole world stopped is what the feeling people get. And the government employees are not working. Are they issuing the receipt notices? Are they issuing the approvals? Are they issuing the RFEs? Are they processing the applications?
Yeah, absolutely. That's the great thing is right now all applications are still being accepted. We're still getting receipt notices in a timely manner, still getting approvals. Processing times, even though we don't have premium processing for I-140s and I-129s, the regular processing times have actually improved. We're getting approvals in as little as 2 months right now, which is great. So yes, everything that USCIS was doing before the pandemic, they're still doing. The only differences are biometrics appointments are not being done, and the naturalization oath ceremonies and green card interviews. Anything that's face-to-face in person isn't done, but everything done by service centers, which is most employment-based immigration, continues to be processed.
Emily, there's in the executive order on April 20th that Trump has issued a statement saying, boom, I'm going to just take the whole immigration off. Then comes the executive order, which is like fizzled down to only immigrant visas that people are applying, especially in the preference categories, in the family and some business outside in the consulate, and that are restricted. Other than that, no more restrictions were being there. But however, there's a provision that in 30 days, the Department of Labor and the USCIS should come with a recommendation. Now there is things that are floating out in the media, mainstream media, that there might be some restrictions on the OPT and STEM. Is that something new that is coming out from the Trump administration based on the COVID response? Or was it there on the agenda? And if they want to make any changes, can they do it with a letter, executive letter, or do they have to go through any law, like do they have to go to the Congress, part of which is called Parliament, or do they have to go to the regulatory process?
Yeah, so the changes to the STEM extension and the OPT, optional practical training, these have been discussed for some time. It's actually been on the regulatory agenda. We were expecting a proposed regulation in the fall. So this is not a new idea. I think what's happening really is the Trump administration is using the virus as an kind of added reason why they think they need to make this more restrictive, but it's not something that's unexpected. And it's not something that the president has the power to just unilaterally say by an executive order, I'm blocking all OPT starting tomorrow, or I'm blocking STEM extensions. He doesn't have that power. Because they were created with regulations, they're all the compliance is through a regulatory process. They have to go through a regulatory process to make changes to that and restrict it. So I don't think we have much to fear from that, at least not in the very near future.
Questions I want to take, Emily. Tanya has a question. Tanya has a question. He's an H1B. His wife is about to get the H4 stamping. And when do you think so the consulates will be open?
Well, yeah, that's anybody's guess right now. Some of them do have appointments available in June, July, so that might be possible. We also have the possibility of an executive order that stops non-immigrant visa applications from happening at the consulate within the next 30 days. That's part of the initial executive order that we were just talking about, and that's the one thing that the president could potentially block is new visa applications at the consulate. So it's hard to say. Hopefully they will open this summer, but we might see more restrictions on that.
Question from Dan. Can I withdraw the 401k plan with the new CARES Act allowance? We are not very well trained in this particular part of the question. Not completely related to immigration. Maybe a CPA would be an ideal person. Question from Abhishek. Is there an will they deny all the STEM and OPT, or will they ban? Emily has already provided the explanation on it, that it's not going to be that easy. If they want to do it, it's going to take a lot of time for them to get it done.
Nendan from Facebook wants to know what physical therapists can do besides change.org petitions or calling senators and sending emails and letters to be included in the Healthcare Professionals Resilience Act. I think a really helpful thing is to get your employer involved. The employer can contact their senator, their congressman. They tend to have more sway, I would say, than an individual. And also a professional association. So if there's a physical therapy association in your state or that you're a part of, you can ask them to get involved in it as well.
Pranbi has this question from Facebook. Does the H1B people need to fill the 2020 census? Yes. You are under obligation to fill the 2020 census. It is, if it's asking particularly, there is like short form, there is long form. The short form normally doesn't ask you much about the US citizenship, but if it asks, you clearly mention you're not a US citizen, but you need to respond to that thing. There is a way to respond even online also. If you got the thing in the mail, there will be a number. You can go to the website, you punch in that number, the details will be there. You can fill it online, you don't even have to mail them. But you are under the obligation, even though you are an immigrant, even though you're an H1B, you're under obligation to actually fill that thing out.
Priyanka from YouTube wants to know, she has a friend who was recently laid off, who is on H1B, has an I140 that's been approved for more than 180 days, and wants to know what options are available. Is there a grace period? So assuming that the I94 is still valid from that H1B approval, there is a 60-day grace period. During that 60 days, he can look for another job and file an H1B transfer. He can file a change of status to another type of visa category that he might qualify for. For example, if he's married and his spouse is on H1B, he could file a change of status to H4 during those 60 days. He can prepare to leave at the end of those 60 days, or if travel is not an option, the next thing to look at is filing a change of status to a B2 visitor visa. That can be done online with the online I-539 form. Most importantly, don't go beyond the 60 days.
Bharatha has this question from Facebook. Whether have you been noticing any raise in denials or RFEs recently? Yes, there has not been a raise actually. It's the other way around. There have been less denials and less RFEs in the past 1.5 months. That's our office experience. I'm not giving in a general sense, but that's our office experience. It's not otherwise. Maybe it's the court litigation where the USCIS has been restricted in this particular court litigation where the judge has said that the USCIS has limited authority in asking the verification letters from the third-party placement situations. And that might be the reason. I don't know whether they are more sympathetic to immigrants when the COVID is going on, but overall, we have seen a reduction in the RFE rate and the denials in the RFE rates.
Venkatish from YouTube wants to know if we have any idea when premium processing will be starting and why PERM processing are taking longer. So with premium processing, we don't have any inside information on that. When USCIS suspended it, they did not provide us with any information about when we might see premium processing come back. It is based on this COVID-19 situation, so it might be some time before they get that under control, and they might bring it back slowly in phases. Well, that's what we've seen in the past. PERM processing, sometimes it's shorter, sometimes it's longer. I think that with that process, it's not run by filing fees. There is no filing fee paid for the PERM processing, so it all depends on workforce availability and do they have enough officers to handle that? Are they busy trying to work on bulk of cases? Are they busy handling prevailing wage issues or H2Bs? They have to shuffle people around, so sometimes processing times get longer. But I don't think there's anything peculiar behind that yet.
Anand has this question. His priority date is December of 2020. Since there is a temporary ban on the green card coming from the council processing, is there a chance that his priority date can be, the priority date for EB, employment based 2 can be moved faster? Yes, Anand, there is a possibility for it, a very good possibility for it. If that happens, you will see that starting from October. And the dates of October priority date will be released in the month of September. So in the month of somewhere between 10th and 20th of September, you may see some improvements if things work out the way we are thinking what the things will work out to be as. That we are expecting to see, because the spillover, the unused preference categories of the family-based should be given to the employment-based. But I'm not sure if it's going to fall into the EB2 criteria. So it may fall into EB1, maybe the leftovers might have to fall into EB2. I'm definitely hoping that EB1 situation should get much better starting from October of 2020, and hopefully EB2 too.
Sabina from YouTube is in H4 status and does not currently have an H4 EAD, but has an EAD from a pending green card application and wants to know if she can get unemployment benefits. So generally, if you have an unrestricted EAD, you are eligible for unemployment benefits if you lost your job. So it doesn't mention that she was working prior to this time. So if you did have a job using your green card EAD and you lost your job, yes, you can apply for unemployment benefits based on that EAD.
The question for the Sankar is that my wife has H4 EAD until November of 2020. She got picked up in H1B in 2000 and filed on April 21st. Do you need to file her H4 EAD? Mr. Shankar, I would file for her H4 plus EAD as a backup plan, because H4 plus EAD is taking a long period of time. You don't want to wait until the end to file it. I will file it, and if you get the H1B approved, you can do one thing, you can withdraw the H4. There is also a situation called automatic revalidation if your H4 and H1 both gets approved. It's a little bit complex to explain in this 1-minute Q&A here, but you can set up an appointment with any lawyer and they will be able to explain what this automatic revalidation is by you going to, your wife going to Mexico or Canada and switching back to this visa or that visa without going through the stamping or any longer bureaucratic measures.
Dipjyoti from YouTube is currently in H1B and wants to know if it can be allowed to rent an extra room on Airbnb or drive Uber or Lyft in order to earn extra money. So definitely not Uber and Lyft, as that would be considered unauthorized employment. When you're on H1B, you can only work for the employer that has sponsored you and only under the terms and conditions that are mentioned in your H1B petition. For Airbnb, if you're receiving a 1099 from Airbnb for the profits, I think that is a problem. A 1099 is given for miscellaneous income as in independent contractor. That means you're actually doing work. So I think that could be problematic. So I would not recommend it.
Sudarshan has this question. He is on a CAP exempt H1B working for a university. Can he enroll in an online MBA program while working on a H1B? Absolutely you can. You can enroll in an online program. There are some prohibitions Emily and I was speaking about many times, that don't enroll in the online universities. That was only applicable if you are on student visa. You're supposed to attend the classes. That's the only reason why you're here on a student visa. But on H1B, if you want to enroll in an online MBA degree program, please, you can do it, absolutely. Just my personal suggestion, make sure that the degree is from accredited university, because that's very important. If it's not an accredited university, you may not have much value. That has nothing to do with immigration. That's just my personal advice to you.
Let's see here. Jagruth from Facebook wants to know if it's wise to change employers given the fact that we don't have premium processing. So there's a little bit of added risk in changing employers and starting working for the new employer based on the receipt notice. Because when you're moved to the new employer, if that transfer petition eventually gets denied, that denial does put you out of status versus continuing with your current employer and waiting until you get the approval and then joining. So with premium processing, that was a much easier thing to do because you only had to wait a few weeks and have the new employer agree to hold off hiring you for a few weeks. Now we're looking at maybe a few months of processing time, so the employer may not be willing to wait. So you really have to weigh the pros and cons of possibly losing the opportunity versus what is the likelihood that this petition could actually be denied. For H1B transfers, they can't just randomly deny them. There are generally things in the petition, in the filing, that could lead to a denial. The specialty occupation is one of the main reasons for a denial right now, where USCIS does not think that the position requires a bachelor's degree in a specific field. So you need to make sure that the position you're being sponsored for does qualify as a specialty occupation. Look up the employer on the USCIS Employer H1B Data Hub and look at what their track record looks like. Do they have a bunch of approvals in the past? Well, then it's probably relatively safe to join them. But if they've got a bunch of denials last year, maybe it's not a good idea to join because yours might have a higher risk of denial.
Question that comes from Gary is that change of status from H4 to F1, the child is turning 21. Can I file at my own? My answer is no, don't do it. Can you come to me to file it? No, I don't do it. I don't know, Emily does it, but I don't do it. The reason is that when the person is turning 21, if you file H4 to F1, if the F1 is not approved by the time the kid turns 21, the F1 will be denied. So so if they're turning 21 and F1 is not approved, you're supposed to file a B2 application. B2 can only apply for 6 months. So sometimes if the kid is turning 21, you apply for F1, then you apply for 1B2. And then that takes a long time, F1 and B2, then you apply for one more B2. And sometimes you have to apply for total 3 B2s, and then F1. This is a complex process. Now, it's not that I cannot do it. People are not willing to pay money for doing that work. And that's the reason I shy away. But if you drop an email, our office doesn't handle this much because people, it's a simple task, but it takes a long time, need to understand every little thing. We recommend going to a law firm, not filing by yourself. Emily, one other thing I need the discussion. Mr. Garia from Facebook asked this question, that what are these 4 senators' letters? Why is the Indian media going crazy? And I don't see anything in the US media. Do we need to be fearful? What is this senator letter? Can that be a law? What is it?
Yeah, so we basically have 4 people that are part of the legislative process telling the president that he should use his power to block all kinds of immigration.
Why can't they do it in the parliament, in this Congress?
Exactly. Congress, senators, Republicans, Democrats, the House, they're the ones that pass immigration laws. They're the ones that decide who gets to come into this country and who doesn't, and under what circumstances. Yet they're the ones telling the president, oh, for right now, because we're in this situation, we'll let you decide. Well, that's not constitutional. Only laws
Congress.
can be passed by Congress. They
Congress.
can't be changed by the president unless they gave the power to the president in the law that they already passed. They're only doing it because they don't have the power. There are not enough people that agree with them in order to actually make a law that puts that plan into place. So since they don't have the power to do it, they're trying to play to their base.
So what you're telling is that they don't have the majority in the Congress. They can't get it passed in the Congress. They are just voicing out to the president so that they can tell to whatever constituencies that they are. But it doesn't mean anything in the legal sense. It doesn't make anything in the legal sense. It doesn't become a law.
Exactly.
Yeah. So in the media that that has advertised this one too much, I have seen it's going crazy on these things. Is imagine 4 of the member of parliament in India wanted to do something. That doesn't mean that it's going to be done by the parliament. So please be careful on what they are telling you. And that's the reason why we suggest you to come and listen to us every week, because we know what you want. We meet with you. If you ever think so that we don't have a knowledge, guess what? You're living all the messages we are reading. We should be more knowledgeable on that one. So please come to our thing every week at 5 o'clock. We do present and we do cover all the important things that you need to know.
Srikanth from YouTube has an employer that filed a labor certification for him and wants to know if he can switch to a different employer with a different job title and what will happen to that old labor certification. So you can switch to any employer with any job title that qualifies for the visa that you are applying for. The only time that the jobs have to be similar to each other is if you've already filed your 485 and that's been pending for at least 180 days. Under AC 21, you can take that old green card process with you to the new employer without having to start over, but only if the jobs are similar. If you are before the 485 stage, there's no provision like that, which means that you can take any job that you're qualified for. It doesn't have to be anything related to the old job that you were doing. Now, what happens to that old labor? Well, the employer could withdraw it because they no longer have that job opportunity for you, or they could let it continue to process and then just not file the I-140, but nothing happens to it just because you've left that company or changed job titles.
A lot of people are asking this question, what's going to happen with the biometrics that are required for getting H4 approved? They did waive for some of the category people, especially if they're applying for the employment authorization through the what is it? Dream Kids. What is it?
DACA.
DACA. For those extension people, they were asking the fingerprints all the time. Now they said they waived it, but they haven't waived the biometric requirements for the H4 extensions. Unfortunately, we are hoping that the administration may turn around and do the same thing for the H4 EAD, but we'll have to see. I would request you that you contact your congressman. That's the only way. They can put some pressure on the administration to make such changes, and these changes can be brought by the Trump administration. They don't have to go to the Congress to make those changes.
Sudarshan from YouTube is working for a cap-exempt employer, and his department's hours were just reduced from 40 to 37 and a half. He wants to know if he needs to take any action. Potentially your employer may need to, just depending on the circumstances. Generally, if an employer is going to make a material change to your terms and conditions of employment on an H1B, they have to first file an amendment of that H1B to make the change happen. So it really depends on, does this also include a reduction in salary? That's probably a material change, and the employer should be filing an amendment before that change takes into effect. So it's not necessarily something you need to do, but you may need to suggest to your employer that they contact an immigration attorney to make sure that they're remaining in compliance.
Mr. Sampath from Facebook has this question. When does a 60-day period start? Is it on the day you got laid off, or the day your severance paid days are over? It's on the day you got laid off, not on the severance pay. Severance pay is actually a payment that you are receiving for the work that you have already done, not for the work that you're doing. So don't count the severance pay time. So time of 60 days starts as soon as you got laid off.
Google from YouTube wants to know about interviews that are getting waived for the pending I-485 applications. We have seen that happening. It's not anything that USCIS has announced. It's not anything that's been applied across the board. But we have gotten some reports for people that were able to receive their green cards for employment-based categories without actually attending the interview. Shiv from Facebook wants to know, why is the I-140 receipt notice not coming after almost a month? Does the e-copy with DOL have any miscommunication? Yes, we're seeing this happening. So if you're aware, the Department of Labor came out and said they would start emailing the certified labor approvals, and that you could print that out and have all the signatures on it and use that and consider it to be a valid labor certification. Normally, before the pandemic, the labor approval came on thick blue paper and you had to submit that original one only. So they relaxed that, but apparently they didn't tell USCIS, because USCIS started rejecting I-140 petitions that were filed using this emailed copy of the labor certification. So I had one of those myself. I resubmitted it last week, and the filing fee check has been cashed since then, so it appears that they have corrected that error. But yeah, I do have,
what
we do have some problems with that.
What about the cases that people are filing without the original signatures right now, Emily? I mean, a lot of people are filing that. Is that advisable?
I've not had any issues with using photocopied signatures. We've since they announced that, everything I have filed has been with photocopied signatures, and I've not seen any issues getting receipts. The only issue is the copy of the labor certification with the I-140s.
Amit has this question. Have you seen any approvals in the H1B quota filed in the 2021? No. Zip, none yet.
Nope.
One question that this comes out very frequently is that what to do when you got laid off right now, when you lose the job. What are the options available? I will run through a couple of different options. If you have an H4 option, please go for it. ASAP, no questions to be asked, just go for it. H4 is the best option. Obviously, if you have an EAD, throw that out. Throw that one too. You can have H4 and EAD filed at the same time. The best option if you have the H4 option. If not, let's discuss about the B2 option. Right now, it is advised because of the travel conditions, you cannot leave the country. So you can apply the B2. You can file a B2 application online. But if you're filing for the family, if there are more than one person included in it, they cannot be included on an application. If you want to file for the family, you have to file each I-539 application separately. If you're going to send it, you can do the supplement form of the I-539 and include family members, and you pay each family members $85 extra fingerprint fees. Otherwise, if you file online, you have to file for each family separately. You can do that. Now, you cannot transfer back from B2 to H1B. Technically, it may be possible. Practically, it's not possible, because the time it's taking to get the B2 approval might be approximately about a 1 year period. You only are going to apply for B2 for 6 months. What are you going to do? Apply one more B2, and then to apply for change of status from B2 to H1, they won't approve it unless the B2 is approved. So it's like chicken or egg, which one is earlier? So the best approach is to use the B2 to exit out of the country, and if by any chance you get an opportunity to get another job in the interim period, you can apply for the H1B, but you cannot work. It will be a consular processing where you have to get it. Another question that came out online is where I'm responding, if the job is lost, is an F1 an option? It may not be practical for F1 to be option. One reason is that you have to maintain the legal status until your F1 is approved. And since your legal status terminated on the day you got laid off, plus 60 days, and F1 is taking up to 12 to 18 months. So what are you going to do? Are you going to apply a B2? Remember, we went through the scenario, B2, and F1, that's going to be 18, 19 months before you get a F1. Sometimes it may come in 12 months. So it may not be practical for you to get into F1. And for those people who believe in day one CPT day one CPT is illegal according to us. We don't recommend it at all. Even if you even contemplate of taking the day one CPT, you can't even get the CPT until you move to F1, which is going to be 18 months. My recommendation is that if you lose the job, unless you have the H4 option, use a transit visa of B2 where you apply, use it as a transit, and then you leave the country when the things get much better.
Venkatish from YouTube wants to know, given the current pandemic situation, can we request USCIS to provide a 1-year H1 extension based on a pending PERM or a PERM approval if it was filed within the 6th year? So normally the requirement is you need an approved I-140 or your PERM had to have been filed at least 365 days ago for you to extend beyond the 6-year limit. So even in a pandemic situation, those rules have not been relaxed. Even though there's no premium processing of the I-140, those rules have not been relaxed. There's no basis for you to file that extension, unfortunately. So if you're running out of H1B time, you either need to exit the country until you can get the I-140 approved or file a change of status to some other type of visa until you can get that I-140 approved and change back to H1B.
Any possibility extension of 90-day timeline to file the new H1B paperwork? A possibility, yes. Probability is different. I mean, yes, in the HEROES Act that I have, it's about 1,800 or 2,000 pages. I was able to skim through some of it, and there are some provisions where it extends some of the deadlines of filing the applications. That's there. I was also asked on this HEROES Act by Soccer Hero from YouTube, which branches of the healthcare are covered though. I see, based on my reading, is that the physicians who work in COVID and also healthcare people who work in the COVID, it doesn't specifically restrict it only to nursing professions and doctors. It did open up the field, like anybody who works with COVID is given more importance, but this is a premature reading of this 2,000-page bill that I was able to skim through when I got it about 3:30 or so. So I will give a more presentation when it becomes more serious that this bill is going to be passed. We are expecting a counter bill by the Republicans, and we'll see if there's any compromise on how it's going to happen. We'll keep you updated. Please come to our every Tuesday thing.
Syed from YouTube wants to know if an H1B employee can go on medical leave and not receive a paycheck, and if yes, for how long? So yes, if the employer has a policy that allows someone to take medical leave, and that's unpaid leave, and you're requesting that under their normal policy and have a true medical need, you can take that unpaid leave without impacting your status. So for example, if you need to have a surgery and you need to be off your feet for 2 weeks, you could take a medical leave for those 2 weeks if it's within your employer's policy and you're still considered to be maintaining your status.
H4 EAD, we have a lot of questions on it. Is there any update right now? Everything is standstill, nothing is going on. We suspended the litigation until the court is going to rule on that. We're expecting the court ruling. We will let you know on the court ruling. We have seen a significant more delays that are happening in the H4 plus EAD. And that's the update right now. There's not more any more updates on it. Savi is asking, do you anticipate EB1 to be current for India? There is a probability. There is a probability that EB1 might be current. What do you say, Emily?
Yeah, I think it depends on if the Healthcare Workforce Act passes. That might take.
And what about this wastage, the wastage of the family green cards?
Exactly. Those two things combined might open it up enough to where we could see that happen.
It's a possibility that, but I would not count. It's a probability, but a probability I would recommend to hold on until September. We will be able to get a clear guidance on this. There's also a lawsuit filed on the Trump administration with regard to the implementation of the executive order on the family immigration. So we'll have to see how that will turn out to be also.
Narasimha from YouTube wants to know, what if I start working on a concurrent H1B and then lose that concurrent job? Does the concurrent employer need to keep paying until the I-797 end date? And how does that impact the original H1? Well, if that job ends, if there's a termination of employment, that employer is supposed to withdraw that concurrent H1B, and that withdrawal has no impact on your underlying approved H1B with the original employer. So there's really not much to worry about in that situation.
Sujay has this question, are you filing any court litigation for H4 EAD? No, we suspended the court litigation until the court gives the judgment, which we're about to get. Until then, we suspended it. Can F1 OPTs apply for AB2? Yes, you can. A lot of people ask the question, people need to be on H1Bs to apply for the green card? No! Even on H4 EAD, you can apply for the green card. A lot of people are under a misconception that you need to be on H1B to apply. When we presented last week, a lot of nurses and doctors who are in H4 EAD, then they started contacting. We need to contacting us, hey, you know, how do we get in? And then I said, you can apply for the I140. And they said, no, we can't because we're on H4 EAD. No, H4 EADs can apply for the green card. F1s can apply for the EB1, EB2s, absolutely no problem with it.
Kishore from YouTube wants to know if we suspect any issues at the port of entry for an H4 with a valid visa coming into the U.S. due to the potential upcoming executive order. It's hard to predict, you know, you never know with the Trump administration, but if we look at the first executive order that blocked immigrant visas, those that already had the immigrant visa approved and in their passport were allowed to enter, assuming you could get a flight. Those are not blocked. So we would assume or expect that the same courtesy would be given to non-immigrants who do already have the valid visa. They should be able to travel on it.
This question comes in, is there a chance to apply, get the secondary H1B lottery if I did not get picked? Yes, there is a chance, especially with the pandemic situation, there is a chance. If that chance is there, it will be only after June 30th that chance will be there. But Sai, if I were you, I would not rely on it. It's a very less probability, and also your chances of getting in that will be less. I would not count on that and rely on that to plan my life. I would like to plan it without it, and if it comes in, that's fine.
Ren Bala from YouTube wants to know how important the statement of work is for an H1B extension for someone working at a client location. Well, USCIS usually wants to see the actual contract or the MSA between the two companies plus an end client letter plus the statement of work. They want to see all three documents. Now, if you only have two of the three and you file it, you might get a request for evidence asking for the statement of work. There is some recent lawsuit results that would be in your favor on that, basically stating that USCIS doesn't have the authority to ask for those additional documents. So that might be helpful if you get into that situation, but I would expect USCIS will still be looking for all three of those documents.
Vineet has filed his H1B in premium processing in January, got an RFE, responded to the RFE. Now, is the response to the RFE will be considered under premium processing? Yes, it will be considered under premium processing. I've had people calling me, it's been 15 days, I did not still get any adjudication. Yeah, just wait, how you calculate 15 days is not how they calculate 15 days. It's not how we calculate 15 days. So it should be adjudicated. We haven't seen USCIS coming and refunding any of the monies at this point of time.
Samir from YouTube has his wife's EAD has expired, but she does have a prior H1B and wants to know if it's possible for her to move back to H1. If her employer is willing to sponsor her, absolutely. You can go back to H1B without going through the lottery process again and get whatever remainder time you had left in the 6-year limit. If she also has an approved I140, then the 6-year limit doesn't apply at all and she's eligible for 3-year extensions.
One other thing that I'm thinking about, if it's the same employer that wants that person, Emily, she can do automatic revalidation, can she not?
Assuming that petition hasn't expired yet.
Yeah, it has
absolutely.
not expired, and she wants to go join the same company. She can do automatic revalidation. You can consult any lawyer. It's a very simple process because there is no premium processing. This won't take a time. It's just a like 2 days time. You can get that thing done. You can consult any lawyer. They'll be able to advise you on that. One question that came from Susant from YouTube is, my employer is filing an I140 application along with the PERM approval. Now, can I file the EAD application along with the I140 application? No, you can't. You have to wait for the I140 approval before you file an EAD application. Unfortunately, since the premium processing is suspended, you don't have much option other than waiting.
Sohail from Facebook has an I94 that's expired and an RFE that needs to be responded to by May 20th and wants to know what options are available if the H1B application gets denied. Definitely not a great situation to be in. If a denial occurs after the I94 has expired, the denial puts you immediately out of status and unlawful presence does start to accrue. If you cannot travel at that time, you can try filing a nunc-pro-tunc change of status to B2. That means it's a late filing because you've already fallen out of status at the time of filing, but you're requesting them to excuse the late filing due to the extraordinary circumstances of not being able to travel and receiving this unexpected denial.
Can we use the previous company's I140 approval to file with the 485 application with the new company? Good question from Mohit. Answer is no, you cannot. The new company has to file an I140 application, otherwise you cannot file the 485 application.
So Rob from Facebook wants to know if an employee has been furloughed or on an unpaid leave of absence, does that period count towards the 60-day grace period? If you're in H1B status, yes, it's not possible to be furloughed or to be put on an unpaid leave of absence by the employer when you're in H1B status. That does put you out of status and your 60-day grace period begins.
Pranjana has this question. Do you think the approved H1B people from foreign countries, can they travel in October 2020 as usual? I don't see any problem in them traveling in October of 2020. I don't see any problem once they get to stamping. They should not be having any problem.
Chetan from Facebook wants to know what the current I-140 processing times are and if the president can stop or delay I-140 processing for people that are in the U.S. So current processing time depends on the service center and depends on the category. If it's an EB1 category, those are taking a year to process. Regular plain old EB2, EB3 category are taking maybe 2 to 6 months depending on the service center. And I don't think the president has the authority to stop I-140s from being processed. Those people are one step away from being lawful permanent residents, and they're inside the U.S. I don't think he can tell USCIS to stop processing.
Emily, I have this question I want to have your attention on. How can the OPT, if the OPT students wants to work for 2 different companies, is there any process for it? How can they work for it?
For an OPT student?
OPT students.
OPTs that are within the first year of OPT can generally work for multiple employers, but it all has to be directly related to your field of study. During the STEM extension, then you have to have both employers that are E-Verify and both employers that do the training plan and actually comply with the training plan. I wouldn't say it's impossible, but it's unlikely that 2 employers would be able to give you the supervision needed on site during the STEM extension. So it may not be as possible to have multiple employers during that time.
And also for the people who are in H1B, if you want to work for multiple employers, this is a great chance for you now. Since you're working from home, you have a lot of time to spare, nothing but you travel time is paid. You can do so if the new employer is going to file a concurrent filing. A lot of people don't know that they can work for 2 employers. You can, absolutely. You can work for company A, the second company that is filing. You can work for 2 companies for full time. You have no obligation to inform the first employer according to the immigration law. I'm not going to enter the contracts law, but according to the immigration law. You can work with company A, you can work with company B, but you need to tell the company B to file a concurrently working. That means that you work with A, you work with B. In this case, you have to inform the company B that you're working with A. You can do so, and in the past 2 months, we've seen these concurrent filings raised up very significantly because people are working from home. They can work for longer hours and sitting at home, traveling time. A lot of things have changed right now.
Mala from Facebook says his I94 in the H1B extension approval is different than the most recent I94 in the CBP website. Is there any issue? So it really depends on the order of things that occurred. So for example, if you received your H1 extension approval notice with one I94 and then you traveled, when you come back in, it's absolutely correct. CBP is going to give you a different number on your I94 that's not going to match your approval notice anymore. So if you travel after the extension is approved, your new I94 number is the one on the CBP website. That's your correct last I94. If it's the other way around, where you traveled, got an I94 number, and then you filed your extension, and that extension has a different number, there may be a problem there. The extension may have been filed with the wrong number. But the only real way to fix that is just to travel again and get a new number when you re-enter next time.
Krish asked this question: is there a change in the grace period from 60 to 120 days? Let me add the question to you. Is there a change from 60 to 240-day rule? We have seen the Indian media a lot, and they say, well, there's a 240-day rule, which we didn't know what they're speaking. They completely misread that law. They completely misinterpreted it. There is not been any extension of the 60-day grace period that is allowed in the law, in the regulations that were passed in the January of 2017. None, zip. It's only 60 days. If you lose a job, you have only 60 days grace period. And that too, your I-94 should have been valid. If your I-94 expires within 60 days, that is, the I-94 will control, not the 60-day. It's whichever is the shortest, the I-94 or 60 days, whichever is the shortest.
Anik from YouTube has an approved I-140 for more than 180 days and wants to change jobs, and wants to know if the new employer needs to file a new I-140 or if the PERM process has to be redone. So assuming that you have not filed your 485, then yes, the new employer has to file a new PERM and a new I-140. When they do that, they can recapture or retain your priority date from the old I-140, so you don't really lose your place in line, but they do have to go through the process again.
Can a new employer become can an old employer, become a part-time concurrent H1B employer? This question comes from Anita. The answer is yes. However, the old employer has to file a concurrent H1B application. I know that now you move to company B according to your statement. Can you work for company A? You can, but company A has to file a concurrent filing. If they don't, you cannot work for two companies.
Raja from YouTube wants to know if the notice of filing as part of the PERM process is allowed during the current situation or it's defective. So there have not been any relaxation of the rules for the PERM notice of filing, and it does have to be a hard copy posting at the work location. So if your work location is closed and everybody's working from home and your employer goes and posts that notice at your office, it is defective because no one's going to see it. So we have a number of companies that aren't able to do their posting notices right now. It's causing a delay in the PERM filing process. Now, if your company is open business as usual and everyone's coming into the office and they do the posting, that's totally fine.
This question comes where the amendment is pending, but the existing validity is there. Can I go for stamping? No, not advisable, not recommended, because your amendment is not approved. The consulate will not, most probably, 19% of the time. I'll be very surprised if they will approve it. They cannot approve your H1B, so don't go right now until the amendment is approved.
Pavan has an H1B transfer pending and has already joined that company with the H1B max out of July of this year. I-140 petition is still in process. He wants to know if the transfer needs to be approved before the max out. Well, if the transfer is still pending and you hit your max out date, you can't keep working just because the transfer is still pending. You can only work until your max out date, even if the transfer is still pending.
Ayer has this question. due to the job market conditions, do you recommend delaying graduation to avoid the problems in the OPT if you don't get the employment or post-completion OPT? That's a good question. I might do it if I were you. I cannot advise you what to do. If I'm not going to get an employment opportunity as soon as I graduate because I get the OPT, I may delay it. I may want to retool myself. If I'm studying, law, maybe what's the law with, the relationship where I can help in the COVID situation, lawsuits related to COVID or whatever those things that are related to those things. In your situation, like for example, I'm seeing a lot of demand in the finance sector because of the stimulus bill, and also I'm seeing a lot of demand in the security sector and certain other aspects of it. If you're in computer science, you can take some extra courses that may actually help you in the situation. So yeah, if I were you, I may delay the graduation. That's a good question, though.
Kumar from YouTube has an H1 extension that was filed in the 6th year and also filed an H4 EAD as a backup and wants to know if we have the option to choose the H1 or the H4 EAD upon approval. So yes, you basically do. So if the extension is approved first and then the H4 and EAD are approved, you're in H4 status. So if you want to get back to H1B status, you would need to travel and re-enter with the H1B approval. Other way around, if the H4 EAD gets approved first, well, really it doesn't matter. The way to choose which one you want to work for, because you can only hold one status at a time, is to enter on the one that you want to work for if it's not the one that's approved last.
There are a lot of questions coming on the healthcare related bill. There are some presentations we did on the nurses and doctors the last week and the previous week. Right now there are many bills that are coming out. Previously on the resilient bill, it only listed out as doctors and also physicians, licensed physicians, and only licensed registered nurses though. However, in this HEROES Act, which is about 2,000 pages, they did include provisions of the people who were in healthcare, so the definitions are not clear right now. There is a lot of vagueness on it at this point of time. We will, once things get, there are so many things coming out, healthcare bills right now that are related to the immigration. So it's very hard to keep up with everything, but the main important thing, what we think has a good possibility, we did cover it last week, that is especially with related to the nurses and physicians. Those are the only two professions. In that bill, we particularly have seen that physical therapist, occupational therapist, speech therapist, a lot of other allied medical field people were definitely not covered in it. In the HEROES Act and also in certain other acts, we do see that the other professionals other than just physician nurses were also touched upon. But at this point of time, we are only giving seriousness to the healthcare resilient bill that covered only physicians, because that has a good possibility of passing according to us.
Sai from YouTube wants to know if there's a chance for a second H1B lottery since many. Oh, you did already? Yeah. All right, never mind.
I think it's time.
All righty, yep, that's about it.
Thank you guys, but don't forget that we do have a 50% off until May 15th if you book an appointment. That's only until May 15th, and after that the prices will be in the normal because of the COVID situations. We do bring in every week at Tuesday at 5 o'clock. Please bring in. Don't try to look into all the rumors. We understand you, we know you. We sometimes know much better than what you should know about your situation because we know about the immigration. We are immigration lawyers. We deal with you guys.
Thanks for joining, and remember we do have a free daily conference call that you can join. You can go to rnlawgroup.com to get the details.
Thank you guys for coming in.